before it works. Great. Thank you so much, everyone, for being here at the final, like the 6th Let's Talk About Legal Design series of this year that the Digital Law Center at the University of Geneva and the Legal Design and Code Lab at the University of Lausanne co-launched. Yeah, so this is the 6th edition. We hope you enjoyed it so far. You must, since you're here. We had a lot of very interesting talks, and I'm very excited also for today's talk on legal design, deceptive design, and fair design by Arianna Rossi. So what we did, or what the goal of this learning call series or seminar structure series is or was for this year, was really to bring in the knowledge that we have also here within Europe and within our network on legal design, bring interesting people to explain and tell us a bit on what they've been working on in order to advance this young field of legal design and connect and hopefully create ideas and new project ideas that can emerge from this. This is the end of the year, even though it's super hot, at least at this side of the globe, or like for me, here in this room. But it's the end of the year. We had 6 very interesting talks. If you have other ideas for topics that you would have liked covered, please email Yaniv or me anytime. We're happy to, work and think about how we can continue this learning series and by inviting also other people within the domain. So today, as I mentioned, we have my colleague and the great researcher Arianna Rossi here to talk about legal design, deceptive design, and fair design. Arianna is at the Scuola Superiore di Sant'Anna, as you can see on this very nice first slide. She has been, she's one of the people that really combines very nicely all the knowledge in legal design, having worked on human-computer interaction, the legal field, but combining also like computer science domains. So it's very nice to have you here today. Arianna already during her PhD worked on legal design, and we were just talking about this before. Probably one of the first theses with the title Legal Design for the GDPR, if not the only one within Europe. So Arianna has been very long working on these methodologies within that domain that combine all the expertise that she has. And so it's very nice to have you here on. So what we'll do now is that, Arianna, you have the floor for, say, a 30-ish minute talk to present to us, your findings, your know-how on the topic. Then we'll stop the recording. We'll have an open Q&A session. We always encourage people also to ask their questions within the chat so that we can pick those up, especially people who maybe are on mute and cannot connect via the microphone. Just please ask your questions in the chat, and then we'll relate those back to Arianna. The Q&A session won't be recorded, so only this formal part of the talk is being recorded. Thank you so much for being here, and Arianna, the floor is all yours.
Okay, so good afternoon, everybody, and thank you so much for this introduction and for the presentation. I apologize because I saw that there is already a mistake on the slide on the University of Lausanne. So I will certainly make sure that this mistake goes away when we share the slides. And today I will try to make a link between the legal design, deceptive design patterns, and fair design, especially because design patterns and specifically deceptive design patterns, also called dark patterns, have been one of the, let's say, hot topics in HCI and law research in the last few years. But it's also been a very important topic for policymaking and the newest legislative initiatives, not only in Europe, but across the world. So today, what I'll try to do in the next 30 minutes, and try to bear with me if I will jump certain sections, and maybe we will have time to speak about those during the Q&A. I will first start from what deceptive design patterns are and the persuasive role of design in general, and why legal design has such an important role in this area of research and practice. And I would also make sure that to illustrate why it is so important to do legal design research, especially for having an impact and producing evidence-based policymaking, which is something that Europe is really trying to strive for, but we not always succeed, let's say. What I will also try to do is that we have probably you've already talked in some of the latest seminars about the transparency design patterns. It's been for sure one of the topics of my research in the last years. And indeed, I will show you a couple of studies in this respect. But also lately I've been let's say, researching much more fairness, and how fairness is maybe even a more important topic than transparency, or at least it needs to go hand in hand in transparency if you really want to get rid of deceptive design patterns. So to start with, what is very, very important to always keep in mind is that especially UI UX design, but maybe any kind of design practice, always have a persuasive intent. And indeed, there is even, let's say, an area of practice which is called persuasive design. And the intent of persuasive design is influencing human behavior through a product's or services characteristics. So this is very, very important. Okay, design can influence human behavior, and as you may know already, can influence it for good reasons or for evil reasons. And this is exactly where we sit. So on the one hand, legal design, or actually the design of interfaces mostly, has been used to facilitate decision making and to facilitate to be informed. Okay, so how do people get information, for example, about data protection, about their consumer protection rights, and then how they take decisions in this context. Okay, and one of the way to do that, legal design has had a lot of let's say success. Especially in the area of transparency and usability. And just to make an example, since the General Data Protection Regulations was approved, there has been a lot of research and practice on the implementation of the transparency requirements that the GDPR introduced. Okay, so maybe you're not familiar with those, and we're not going to that to delve in depth about those. But the main idea is that the GDPR looks at how information is provided to users about the privacy and the data practices, and it prescribes the fact that that information needs to be user-friendly. Okay, so it needs to be transparent, it needs to be written in a way that is accessible, it needs to be designed in a way that makes sense for a human decision maker. And one of the very first examples of legal design, maybe you've already seen this one, is the privacy policy of Juro that was redesigned by one of the, let's say, most important and most influential legal designers in Europe and probably in the world, who is Stefania Passera. And if you don't know her, I really invite you to check out her portfolio, for example, because she's doing amazing work. And as you can see, I will not go into the deep dive, but basically this the privacy policy that you can see on the screen is very different from the privacy policies that we have usually in mind, which are a wall of text. There are no headlines, there are no graphical cues to help the reader skim through the text, for example, and find the information that she or he is looking for. And this privacy policy is very different because it's very concise, it is very well structured, it has icons, it has timelines, and it's also layered, which means that there is the basic information on the first layer, and then if you want to delve into the details, for example, because you're a lawyer or you're regulators, then there is also a second layer in which all of those details are there. But for the, let's say, for the lay user, right, for the normal user, then a first layer with the let's say the top information is more than enough. And another example, again by Stefania, is this part of a privacy policy that details how to make use of your rights as a data subject. Okay, and what is important about this is that usually in privacy policies, what you would see would be, you have also these rights: the right to erasure, the right to access your data, the right to object the processing, and it's kind of a list within a block of text. But this doesn't really, it's not really usable in the sense that doesn't really help the user to make use of the rights that they have. Okay, and this is very different because it's not like a list. It really explains how you can make use of your rights. There are instructions, okay, so that even if you don't know how to do that, then you can follow those instructions. And also it kind of cover your expectations in the sense that, okay, what happens after that I ask for example, my I don't know, the right to access. I will send a request, and then you will need to wait for a response, etc., etc. So this is a very different way of presenting information, of providing information, especially about how to make exercise of one's own rights, which is really something that follows the newest transparency requirements that the GDPR introduced. So the GDPR was really a game changer. But we'll not only focus on this. What I just want to mention is that it was such a game changer, and also it introduced design requirements which were very important, that the Data Protection Authority of France, and if I'm not mistaken, you actually invited one person from the CNIL in a few weeks ago. They actually have set up a platform where you can learn about données and design, right? So data and design, so design principles, design patterns on how to best respect the requirements introduced by the GDPR by design and through design means. Okay, so on the one hand, the legal design or the design of legal interfaces or legal information can really help people to be more informed and to take better decisions. However, design has a great potential, has a great power. And as we know, it can also do the opposite. So it can also prevent people from making informed decisions by impairing, right? So by destroying, by eliminating transparency, or by making it very difficult. And this is how we get to dark patterns, or deceptive design patterns. So as you can see here, this interface is, let's say, a real interface from a real service, but we changed something so that you couldn't understand exactly where it comes from. But it's an interface that you see as soon as you land on the website, and it basically asks you to, as you can see, there are 3 different options. I don't know if you can see my cursor, but there are 3 different options: I accept, manage cookies, and no thanks. One of them is much more visible. There is also a pledge for you to basically accept the cookies so that this company can have a positive impact on the environment, which of course is very peculiar, because what is exactly the relation between my right to protect my privacy and my data and their pledge to the environment? I mean, this link is not exactly super transparent, right? And as you can see, I mean, I think that most of you can relate to the fact that the design of cookie banners is not very usable usually, even if things are changing lately for a series of reasons, also because of guidelines, also because of case law that has been sanctioned heavily the providers of digital services who were not using transparent design, who were going against the transparency foreseen by the GDPR. But basically what I wanted to show is that the whole digital ecosystem, now we're speaking about visual interfaces, but we can speak also about, for example, virtual or voice-based interfaces, robot-human interaction, or all sorts of kind of interactions that we have with the, let's say, digital agents. Well, that can be heavily influenced by the design choices that are made. Okay, so our right to privacy, our right to have our data protected, can also be heavily influenced. And in these cases, we speak about digital nudges, and digital nudges have been used to boost consent rates. And there is a lot of research, which I would say pertains to the domain of legal design, which shows that by simply changing how certain buttons or how certain certain options are presented to users, or by changing how the language is let's say portrayed, or the language is represented, then also the choices of the users with respect to, for example, the acceptance of certain cookies or not, is heavily impacted. Okay, so there is, that's kind of a direct influence between the design of user interfaces and the choices that people make. Okay, so we're not as autonomous as we would like to think. And there has been in the last, I would say, 10 years, more or less, when at the same time that legal design also became to be a thing, there's been a growing concern about the fact, and also a growing awareness about the fact, that we could definitely be influenced about the interface and the digital environment in which we make choices. And you have to keep in mind that we make more and more choices in digital environments. And maybe we're going to go towards a world in which actually most of the choices we will make are going to be digital and not physical. And this is how the dark pattern phenomenon was, let's say, identified first, and then analyzed and described in many ways. And basically, dark patterns are design patterns that exploit human cognitive limitations, such as cognitive biases, but also heuristics, such as the fact that, for example, there is a status quo bias, so we kind of stick with the default option. It's very rare that we change, so this is why the default effect is very important to be regulated, because people will just, stick, for example, with a pre-ticked box and not untick it most of the times. We are very sensitive to information overload and choice overload, and we are always overloaded with information and choices in digital environments. So that's very tricky. We also suffer from hyperbolic discounting. So basically, we think more of short-term gains, like accessing a service for free, instead of thinking of long-term risks of loss of privacy, which is also not very tangible, right? So there are a lot of problems there. There is a lot of deception which is used in online services, and also some emotional appeals, and we'll go to that later. So researchers, especially from the human-computer interaction field, but also from the legal field, started to define, analyze, categorize dark patterns, and show the effects that they have on human behavior online. And indeed, also, I will not go through all of these definitions, but basically, in the newest legal framework, which has been produced in the last few years about digital services, and I'm speaking about the Data Act, the Digital Services Act, the Digital Markets Act, the AI Act, all of them, the Data Governance Act, okay, all of them contain provisions that prohibit or heavily regulate the use of manipulative designs. Okay, so there is, let's say, also a growing concern, a growing awareness of policymakers as well. And there's going to be also, you may have heard of the Digital Fairness Act. With other colleagues, we just participated in a public consultation about that, because one of the main topics that is going to regulate, again, is dark patterns. So as you see, a lot of attention on dark patterns. Dark patterns are also happening, they are also mentioned in case law. Okay, so it's a real thing for the law, and it's very interesting, okay, to have HCI topics or terminology used within legal proceedings. And there are also a lot of guidelines and policy papers trying to, for example, give instructions on how to use a certain design patterns, and how not to use other design patterns, why they can be considered legal or illegal. And I will not go into the detail, but just to tell you that there is a lot. But to me, so sometimes what I see a lot is that there are instructions on how to use transparency. Okay, so transparency is a countermeasure to design patterns. So giving information, giving clearer information, giving all of the choices that are needed to users. Okay, these are basically the transparency instructions that are usually provided in guidelines. And I think this is a necessary measure, but it's not sufficient for two main reasons, which I will try to demonstrate in the following slides. One of them is that transparency only worked till a certain extent. And as I was mentioning before, a lot of transparency usually means also a lot of information, which actually contributes to information overload and the choice overload. So actually it is counterproductive unless it is done very well and very, let's say, selectively. Moreover, dark patterns usually act below the awareness level. So transparency will not be a solution to deceptive design patterns. And also, transparency-based solutions do not account for the fact that we as human beings that act within, let's say, human-designed environment, we are susceptible to a lot of different factors. So transparency will not be enough. I just want to show you, for example, what we studied about the framing effect, which is one of the dark patterns that is usually used in consent banners, but also in other types of interactions. As you can see here, let's say that we made a research in 2021 in which we're showing that in our sample, like 30% of the cookie consent banners presented choices in terms of gains or losses, which means that they were enticing people to accept cookies by offering them the best user experience, or they were telling them, if you do not accept cookies, then you will lose certain functionalities of the website, okay, without maybe specifying why. And we kind of had the hypothesis that this kind of what is called the loss gain framing in research had an effect on people's choices. And we studied that. But I will go directly to the study. Basically, we wanted to know whether if framing is used, especially when it's asked in app permission, so another kind of, let's say, consent, we wanted to see whether when framing is used, whether you would augment users' data disclosure, so whether people would say more yes instead of refusing to give certain apps permissions to access certain data, to access certain other applications on the website, on their device, on their mobile device. And we wanted also to see whether framing would influence the trust of the people in the request. And what we did is that we did an online user studies in which we were asking people to install a navigation app, to launch it, and then they would receive a permission request. The permission request would be different for different people. So we would have three kind of conditions. One of them very neutral, saying Atlasy, which is a navigation app that we invented, would like to access your storage. Okay, so very neutral. Then we would have the negative framing form, which would be declining this permission will deteriorate your user experience with the app. And then we would have the positive condition which said accepting this permission will enhance the user experience with the app. And what happened is that we noticed, I will go directly here. Yes, we noticed that when there was a negative framing. Okay, so the negative framing of the request, that would significantly increase the acceptance rate because of what is called loss aversion bias, which is very known. So people hate to lose things, let's say, and so they kind of, so when you tell them, oh, you might lose a certain user experience or functionalities, then people tend to say yes. And this really was something that we expected, okay? It was part of our hypothesis. However, we also got results that were against our hypothesis. Our hypothesis, by the way, was derived by guidelines by the European Data Protection Supervisor on the use of transparency design patterns instead of dark patterns, okay? So let's say we were trying to test whether the guidelines that were given officially made sense on an empirical level. And what we demonstrated was that actually when we use positive framing, something like, oh, accept the app permissions so that you will get a better user experience, people actually were not accepting, okay? There was a significant effect on the acceptance rates and also on the perceived trustworthiness. So people rated the trustworthiness of the app lower than when there was a neutral or a negative framing message there. And there are a lot of reasons for that. But most of the people, only 1% of the people basically were gave motivation to their behavior based on the message that they saw. They actually motivated a lot of other things. For example, even mental models that they have, something like, I thought that if I wouldn't accept, the app wouldn't work, or like I always accept anything because I don't know why I shouldn't, etc., etc. So what is very important about this topic is that, first of all, we always need to test our assumptions, and especially when we do evidence-based policy making, we give instructions. Okay, we give this kind of guidance to companies. It would be important to, to really test what we're trying to instruct companies with. And the second point is that there are so many factors influencing decision making that you cannot just put it on the transparency of a message. You cannot just say, oh, when you're giving options to people, you need to present in a very equal way the positive sides and the negative sides of an option, okay, as if that was neutral. Actually, it's much more complex. There are so many other factors that influence on people's choices that we really need to take that into account, okay. For example, the perceived trust, that's very, very important. It's not something that comes along only with the message. And if I'm not mistaken, Aurelia, you actually co-author a very good paper on how transparency does not always enhance trust, which is actually a kind of a given nowadays in policy making, which I tend to be a bit suspicious of. Okay, and then another research that we did, it was very multidisciplinary as well. We were asking who is most vulnerable to dark patterns. Okay, so the fact is that what we saw in legal research, but also in a lot of legislative initiatives, was this: that who is vulnerable to dark patterns? Who is most vulnerable to dark patterns? We're seeing two approaches. One of them is called a universalistic approach, and the other one a particularistic one. I will go very quickly through them. But basically, the universalistic perspective sees whole human beings being equally vulnerable. Okay, why? Because we have cognitive biases, basically, okay, the ones that I showed you before. So we're not perfectly rational, which means that, we're all, equally vulnerable to dark patterns, for example. And this is why there are solutions that have been portrayed, that have been proposed, also the ones by official guidance by the European Data Protection Board, for example. Those solutions tended to favor transparency, okay, tended to favor reflective decisions. And I'm not saying that this shouldn't be the case. I'm just saying, again, that it's not sufficient. Why? Because we cannot always be vigilant and reflecting in all of the decisions that we make. There are a lot of deceptive design patterns, as mentioned before, that we are unaware of. So these kind of solutions will not work in those cases. And also because there are other factors of vulnerability, which are very important and very influential. I will get there in a second. Then there is the other perspective that we saw. Okay, so there are certain, and this is very specific, for example, consumer protection law. There are certain groups which are inherently weaker than other groups. Think of children, for example. So they deserve a specific protection, a special protection, more than others, which again is not true, right? But maybe it's not as accurate as it seems, okay? And this is why, for example, there are certain solutions in this respect that tend to enhance comprehension, okay? For example, even data protection law says if there are messages towards children, try to use a child-friendly language. And again, I'm not against this kind of policy mechanism, of course, but I'm saying, again, that it's not enough. Why? Because these kind of solutions assume that people that dark patterns are a problem of information asymmetries. So the moment in which you give better information or more information to the power which is weaker than to the party which is weaker than the other, then this party will have enough information to act on an equal ground, right? And again, this kind of view ignore that there are other factors of vulnerability. I will not go into the details, but what I want to focus here on is that the concept of vulnerable consumers is really evolving, okay? From the UCPD, which identified consumers as a particular group of consumers who are particularly vulnerable, then we can see that actually in digital settings, there is a growing awareness awareness that anybody can be vulnerable. It's actually a state. It's not like a group to which I belong. It's a state in which anybody can pass by, basically, in which an individual can be placed at risk of harm. Okay. So everybody is potentially vulnerable. So we're really getting towards this kind of awareness. But the fact is that if everybody is potentially vulnerable, we had to question, first of all, how do you measure that kind of vulnerability? And is it possible there are anyhow certain people more vulnerable than others, right? Because otherwise it would just equalize everybody. And yes, then children would be as vulnerable as adults, for example, or maybe everybody is vulnerable, but then there are certain people that, according to certain characteristics, certain factors, are more vulnerable than others. And this is the view that we actually uphold. This is very important because all of the many important legislations that regulate digital matters have or adopt a risk-based approach. So if you want to measure risk, then you really need to address those factors of vulnerability that put certain people more at risk than others. For example, the GDPR has certain provisions about vulnerable groups. And for example, that's a very important factor when you carry out a data protection impact assessment, a DPIA. The Digital Services Act also has some provisions about vulnerable people. And there is, it foresees also systemic risk assessment for very large online platforms. It's what is very interesting about the DSA is that also it foresees the fact of device or understanding what are the risks with civil society, with design methods, with experts that also have more of a empirical, let's say, background or research methods, and not only, let's say, legal, which is very, very important, to kind of welcome this kind of expertise within a risk assessment methods. The AA Act, you may know that as well, right? It's a risk-based regulation. It prohibits certain practices because they exploit human vulnerabilities. So just to focus on the conclusions, the article is very long and it's in open access if you want to read it. But basically, our main focus was okay, but then how do we reliably determine risk and harm under those circumstances? Especially because what we reviewed a lot of literature on deceptive design patterns. And what we understood is that there are certain macro factors which are very influential, okay? So they belong to the macro system where human beings and technologies interact. For example, the market environment, okay? If we live in a market environment in which everything is based on data exploitation, then you cannot just act locally on the interface because it's the system in which you are interacting with technologies that puts you in a vulnerable position, right? So that's very, very important in terms of digital architectures. And this is why, only acting on user interface is not enough. We have mesofactors, okay, it's more of the immediate environment in which people live and act, okay, and we saw that there are determinants related to socioeconomic conditions, for example, because also they relate to the kind of devices that you use to go online, for example. So this is very important because people that are using mobile devices, for example, they are more vulnerable to dark patterns. And then there are micro factors, there are individual conditions. They can be cognitive biases, but it can also be age, it can be mental health, it can be an employment status. As you can see, it's not a state, it's not an intrinsic characteristic you cannot change. It's more of a state in which you can enter and get out of. So it's very, very complex, right? But what we argued is that vulnerability to dark patterns is multi-layered, and it's very important to really consider it as such, especially when we're thinking about how might we propose solutions. And I still have a few slides and then I'm done, because I see I already reached the 30 minutes limit, but if you will bear with me, I will get to the conclusions. The idea is that when we do research and practice in what I call legal design, but basically is really the interdisciplinarity between human-computer interaction, for example, UX, UI design, and law. is that there is a lot really that we can do there. We can provide evidence of risks and harms, and this is very important for evidence-based policy making. It's very important that when we run user studies, we enlarge the population that we include. It's very important also to keep track and address all of those kind of concerns when we apply risk assessment methodologies. When we propose mitigation measures, for example, official guidelines, it's again very important to have evidence-based guidelines. And lastly, it would be very important to kind of support a fair by design approach to design of technology. So by design, right, instead of always acting on the harms that people suffer, because it's very hard to demonstrate harms, especially when there are micro harms in digital environments. So just to get to the end, this is a paper which is going to come out very soon. Basically, not transparency, as I think many people already knew, but as I hope that I could show through these user studies, it's not the solution. It's a very kind of easy fix in terms of policy measures, but fairness must be much more worked on, because transparency acts locally, okay, and it cannot address all types of vulnerabilities, whereas we should really work much more on fairness. So fairness is much deeper. Sometimes it's also much more difficult to give guidance on this, but as a dark pattern community, we're really asking ourselves, and we're really trying to come up with a solution about what are fair design patterns, no? So if we prohibit dark patterns, then what can we propose as fair design patterns? But then it's more complex because you need to go into systemic intervention. So you need to ask why exactly, also economically, are those design patterns adopted? So deceptive design patterns adopted, and what kind of economic incentives can we give so that companies adopt non-deceptive design patterns? Okay, apart from saying, oh, it's the law, because it's not an argument that will work. Okay, I would say, oh, there are going to be fines. That's not an argument that will work, because there are certain companies that are so powerful that they don't really care about the fines that they get. It's just a risk. It's just a business risk. And accountability, I think, is a very, very important point, which is also very difficult in these kind of environments in which the supply chain of AI systems, for example, of data is very, very complex. So how to assign responsibilities and accountabilities in this chain of actors is not very easy. So to conclude, I hope I could kind of hint at the fact of why legal design is very important to legal education, research, and practice. One of the reasons is that it helps to challenge assumptions, especially domain-specific assumptions. The law, until I was writing my thesis, it was almost a blasphemy to say that consumers are not rational decision makers. Right now, I think it's something that we have all embraced. But it's very, very important that we carry out evidence-based research in order to challenge assumptions maybe have been there forever. So it's very hard to challenge them. It's also very important to account for multiple influencing factors of behavior, especially in complex digital environments. It's a very hard type of research, of course. This is why we need to build multidisciplinary teams. It's also important to do legal design because it's a way to address, so to design systems, products, interfaces, services that are compliant by design. So instead of acting reactively on the harms, we want to act proactively on how we design those systems. And it's also a way for us as researchers to have a meaningful impact, okay, a real scientific impact, for example, on policy making, which is a way of having an impact on society. And with this, I will stop, and I'm very happy to take any question or even comment, and please challenge my assumptions and my ideas. I'm very happy about that. Thank you.
Great. Thank you so much, Arianna, for this excellent talk. I'm sure there's going to be lots of questions. I'm happy if you guys want to just raise your hand. I personally